The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
I'm an attorney with O'Flaherty Law, and today I'd like to walk you through a how-to video on how to fill out a petition for appointment of conservator. In Wisconsin, it's guardianship form number 3350, and you would fill it out on your own behalf, asking that the court appoint a conservator over your financial estate. It is basically like a guardianship of the estate. It gives your appointed conservator, provided that they accept the position, the ability to make financial decisions on your behalf because you are no longer able to. So I have the form pulled up here on the screen, and we'll start at the top. You'll see State of Wisconsin, Circuit Court, and then you'll fill in the county that you're going to file the petition in. In this case, it would be your county of residence. In the caption, it says, in the matter of, you'd put your name and date of birth. You don't put in a case number. When you file the petition, the court will enter a case number identifying your matter. However, if you later file an amended petition for appointment, you would use the same case number that was assigned to you when you filed your original petition. You'll see an empty blank square over to the right of the page. Don't put anything there. That is where the clerk of court will file stamp your document and put other identifying information if necessary. So that's just for the court. So this is a sworn statement in your petition. So you will be making these statements under oath, which means when you're finished completing the petition, you don't sign it. You wait and sign it in front of a notary, and we'll go over that again at the end of the how-to video. So we'll begin at the beginning. Under oath, I state, paragraph 1, I am unwilling or believe that I am unable to properly manage my assets or income and voluntarily ask the court to appoint a conservator. So you have to be doing this of your own free will. You cannot do this under duress and have it be valid and enforceable. And again, this is a sworn statement. Paragraph 2, you state that you're an adult resident of, you list the county that you're in, so this would be the county that you live in, which is also the county that you would file this petition in, and you'd enter your mailing address. In paragraph 3, you're going to list the approximate value of all your property. That's going to be cash and bank accounts, any real estate, any other liquid assets, and then of course anything else that you own that's of value other than your clothes, your personal mementos, things of that nature. In paragraph 3 sub A, you'll list if you have assets that are previously derived from or benefits now due and payable from the United States Department of Veterans Affairs. If you have none, just say none. If you got or are getting benefits from the Department of Veterans Affairs, you need to list them, and that's a lot of information. So what you can do is you can list them on a separate sheet of paper, and then you can click See Attached and attach that sheet of paper to your petition. Paragraph 3, subsection B, you state whether or not you receive any public benefits, and those include medical assistance, Social Security income, Social Security disability income, or long-term community options program benefits. Now, if you don't get any, you just click no, but if you do, you would list the type and amount, and if they can't all fit on this tiny little line, you can do the same thing as you did in the previous question. You could just write See Attached and then list them on a separate sheet of paper that you attach to your petition. Paragraph 3, subsection C, is for everything else. So if you receive any other claim, income, compensation, pension, insurance, or allowance to which you get or you may be entitled, you either say none or as follows. and you list them here. This isn't a lot of space, so again, you can put them on a list on a separate sheet of paper and click See Attached. This would be for any other Social Security you receive, any kind of private pension, if you receive investment income, and then of course there's the catch-all category Other here. They want to know how much money you're going to get every month from these assets. Paragraph 4 asks whether or not you have a current, valid, financial durable power of attorney activated. If you have somebody who is named as your financial durable power of attorney, you need to list their name, address, and phone number in this petition. In paragraph 5, you can nominate who you want to be conservator for your estate. This is a question that you want to give a lot of thought to, because when you ask for someone to be your conservator, they're going to have complete power over your finances and what you do with them. A lot of people tend to nominate a child or a spouse. The important thing is that you think very carefully who you're going to select, with the understanding that if things go bad, you might have to go back to court to have them removed as your conservator. They can't just walk away. Or you might want to nominate someone you're not related to, someone that you have a business relationship with and have known a long time and have trusted for many years. So you would name your first choice and how to reach them. And then typically they ask for a standby or alternative choice if the first choice for conservator doesn't consent to becoming your conservator. Paragraph 6 involves what powers you petition the court to appoint and authorize by your conservator. So option A is that the court appoint and authorize a permanent conservator to perform the duties of a guardian of the estate under Section 5419 of the Wisconsin statutes and exercise the powers that do not require court approval under 5420 sub 3 of the Wisconsin statutes. Option B asks the court to authorize the conservator to exercise any additional powers requiring court approval under 5420 sub 2 other than to make gifts as follows. So this is really just how many financial powers do you want to authorize your conservator to perform on your behalf. Option 3 is where you petition the court to direct that the custodian of the estate deposit the individual's funds of $100,000 or less in an insured account of a bank or credit union, savings bank, or savings and loan association in the name of the custodian and the ward. You would be the ward, payable only upon further order of the court, and waive bond for the custodian of the estate. So if you don't have a lot of assets and you just want someone to ask the court to authorize them to put a certain dollar amount in a bank, and that it would be payable only upon approval of the court, you can do so. And if you waive bond, you're basically waiving insurance for that person who took that action on your behalf. In paragraph number 7, you make the statement, and again remember that you are under oath. I understand that I will be personally examined by the court at the hearing and that the court will determine the suitability of a nominated conservator or standby conservator. So you'll file a petition for appointment of conservator and you'll get a hearing date. And at that hearing date, the court will ask the nominated person for conservator a series of questions just to ensure your safety and to make sure that they will responsibly handle your finances and that this is all a bona fide situation where you're not being pressured or put under duress to appoint a conservator. At the end of the document, you simply make your request of the court that the court order a hearing on this petition, make findings and appointments as requested above, and the court, you can ask that the court either waive bond or waive insurance or set bond as appropriate. So if you waive the bond, you're waiving insurance that if your conservator grossly mismanages your finances, that they're basically not financially responsible for their mismanagement. So this is something you're going to have to think about a great deal before you decide whether or not you want to waive bond. Paragraph number 4 is other. So if you have other requests regarding appointing a conservator to make to the court, this is where you would fill that out. As we mentioned at the beginning of this video, this is a sworn statement in your petition. So you can fill out all the way to paragraph 4, but don't sign it. You have to sign it here in front of a notary. If your bank has a notary on hand, a lot of banks will notarize documents for their account holders for free. Otherwise, it's relatively inexpensive to get someone to notarize a document for you. You would sign in front of the notary, and you would make sure that you had your name printed or typed here with your address, email address, and telephone number, and of course the date you sign in front of the notary. They will allow a remote notary for these types of documents. At the bottom of this document, there's a distribution list. What that means is who gets a filed copy of this petition. Obviously the court, obviously you, any proposed conservator or proposed standby conservator, any presumptive heirs. So if you have children or friends or a spouse who would presumably inherit from your estate upon your passing, they have to be notified of this conservatorship. Earlier in the document, it asked if somebody had financial durable power of attorney on your behalf. If you do have one, they will need to receive proper notice of this filed petition to appoint a conservator. And then if there's anyone else, any other interested party who you believe needs notice, you can add them under other. As we discussed earlier in the video, if you have additional information that will not fit on the form, don't alter the form. Put it on a separate sheet of paper and say "See attached." As you can see at the bottom of the form cannot be modified, but it can be supplemented with additional material. Those would be your attachments that you put together and attach to the petition. So that is how you fill out Form GN 3350 in Wisconsin, petitioning the court to appoint a conservator. I want to thank you for watching, and if you would like to learn more about guardianship or conservatorship in Wisconsin, you can visit our page. It's linked below.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.